Welcome back, everybody. Today we're going to be discussing the federal judiciary system. In this video, we will be discussing three questions. The three being, what is the federal judiciary? What does the judiciary branch do? And how are judges chosen? So we'll start with the first one. What is the federal judiciary? Well, the judiciary is the court system. In this case, we're talking about the federal court system, which for the purposes of our video, we're going to focus on the district court, the circuit court, and we're going to focus on the Supreme Court levels. So the federal district court is known as a trial level court. What that means is when you go to file a lawsuit, you can file it in federal district court. Now, you cannot just start out by filing a lawsuit in the Circuit Court of Appeals or at the U.S. Supreme Court. After the court has determined the facts, it will apply the law to those facts, and then it will issue a judgment. Now, let's say you did not agree with the judgment issued by this district court. Well, you do have the option to appeal to the circuit court. Now, one very important thing that you have to keep in mind while doing this is the circuit court is not supposed to be entertaining new facts or revisit the facts even and see if what was true and what was not true. But what they're going to look at is how does the law apply, and did the lower court correctly apply the law to those actions that took place? So let's take a murder trial, for example. What they're going to look at is how did the federal district court apply the law to the facts? They may look at that and say, well, he actually did act in self-defense, so we're going to overturn the decision of the court. Now, they might also find somewhere in between where they say, it wasn't self-defense, but there weren't these aggravating factors that the lower court may have decided existed that increased your sentence. So they might say, these aggravating factors didn't actually exist as a matter of law, so we're going to shorten your sentence. Another thing they might do is they might remand the case back to the lower court. They may find some various amount of issues with the way that the law was applied and say, hey, federal district court, you got to retry this case, but you have to retry it within these specific parameters, and then they will lay those out for the court. And then the third and highest level of court that we're going to be discussing today is the United States Supreme Court. This is the only court that's specifically mentioned in the Constitution, actually. And the Constitution actually specifies that it is the Supreme Court and it is the highest court in the country. Now, that being said, the Constitution does give Congress the power and authority to create lower courts as it sees fit. It is also important to take note that the Supreme Court is an appellate level court. That means you're not going to be filing your cases directly with the Supreme Court. You will actually have to work through the federal court system, go through the district court, go through the Court of Appeals, and then you can try to appeal to the Supreme Court. Appealing to the Supreme Court is filing for a writ of certiorari. Once you apply for the writ, you should be under the expectation that the court is going to reject your case and decide not to hear it. That happens to the vast majority of cases that get appealed to the Supreme Court is they decide not to take them. There is some possible exception here. There are some controversial topics where some people say that the court is required to take these cases here and there, but it's a very small amount of cases that ever come up for that. But let's say you're lucky enough and you get your case up to the Supreme Court. Hey, good for you. Go buy a lottery ticket. You get the case to the Supreme Court Court's going to hear it, they're going to issue their decision. They may even remand back down to a lower court to retry your case, just like the circuit court can do. Or they may overturn the decision altogether, or they may modify it. It's totally up to them. Now, when the Supreme Court makes a decision, it binds every court in the country to align with its decision on what the law is. Generally speaking, there's a separation between the federal judiciary and the state judiciary. You'd go through the trial level at the state court, and then you go through their own appeal level, and then you get to the state Supreme Court. Now, there is a chance that you may have a lawsuit where the state law is in conflict with existing federal law. In that case, you can bring a lawsuit regarding that state law in federal court, and the federal courts can overturn or nullify or anything like that the state law in as much as it is in conflict with the federal law. It could be so much in conflict that the state law has to go altogether, or it may be that the federal courts just decide that, hey, no, this law actually has to be modified a little bit because you have to have this carve out here for what the federal law says. So let's say you go through the entire state system and you've gone through the state Supreme Court, but the law you're challenging, it really has a conflict with federal law, or you really believe it does. and you don't believe that the state system has rectified that by themselves, you can actually appeal from a state Supreme Court directly to the United States Supreme Court. You would go through the same process as requesting appeal with the Supreme Court as you would in the federal court system already. You would you would file for a writ actually of certiorari, and again, be very prepared that the court will not take the case. If the court does not take the case, the ruling of the whichever lower court it was that gave the most recent decision stands. All right, now we're in what does the judiciary branch actually do? So what it's supposed to do is it's supposed to be there's a referee, interpret the laws, and to be there's a referee between parties who have a dispute. That was at the very beginning pretty much what the understanding of the court system was. Now, the courts have this power of what's called judicial review. It is important to note, though, the court systems did not always have this power, and they weren't originally specifically endowed with this power. It was something that the Supreme Court actually said that it had itself in the case called Marbury v. Madison. And after the case of Marbury v. Madison, no one really seriously challenged the court on this, and it became just kind of a generally accepted idea that the court has this power, and therefore it's kind of become a fact now of American life, where there are still some people who disagree with it and say the court shouldn't have this power, but for all intents and purposes it does, whether you agree with it or not. Just because it's gone so unchallenged for so long, it's just become so embedded in our own political makeup of our country, and there's no real challenges to it. So for all intents and purposes, the court has this power. What that means is it can overturn a law that it believes is in conflict with the Constitution. Now, this has been expanded from the Supreme Court to pretty much all the courts in the federal system. If a district court or a circuit court believes that, no, this law is unconstitutional because it conflicts with the U.S. Constitution, then they can strike the law down, and the law is no longer able to be enforced or anything like that. Now we're on the final question, which is how are federal judges chosen? Well, federal judges, all of them, are nominated to the bench by the President of the United States. Once they are chosen as the nominee, the Senate will have to vote to confirm this individual. Once the Senate votes to confirm, the person is on the bench. And it's important to note that all federal positions like this, all federal judges, are nominated to lifetime appointments. So what that means is there is no term limit. Once the judge has been nominated and they have been selected by the Senate, confirmed by them, and they're on the bench, they're there for life. There's only a few ways that they can get removed. The first way they can be removed from the bench is by death. Of course, if the judge dies, there's an opening on the bench. A president can then nominate and try to refill that position. So another way that there can be an opening on the federal bench is if the judge resigns. If the judge resigns, then there's an opening. Now, the third way that there can be an opening on the federal bench is if the judge or justice, all these apply to justices as well, of the lifetime tenure, all that stuff, is removed by impeachment. Now, the Constitution is very vague on what the grounds are for impeachment of federal judges. This may have been done on purpose to prevent any political shenanigans as much as possible, because really the founders, when they set up the country, they wanted the judiciary to be separated off from the political branches and not under their influence, hence things like the lifetime appointments. There's no reason for the judges to have to run for election. They don't have to please a certain base to keep their jobs or anything like that. Once they're on the bench, they're on the bench, and they don't have to worry about how their decisions may conflict with whatever political party is in power. It's very important to remember, impeachment does not mean conviction. Impeachment only means that charges are brought. That's up to the House. They transfer those articles over to the Senate holds the trial, and if the Senate votes to convict, then that judge will be removed from the bench, and then there will be an opening. It is very important to note, if you aspire to be a federal judge and you're waiting for an appointment on the federal bench, you may be waiting for a very long time. All these people have lifetime appointments, and usually they're there until they die or until they resign. Now, you may be hoping for an impeachment to go through. However, here is the bad news for you. Between the years of 1804 and 2010, only 15 judges at the federal level were brought up on impeachment charges. Of those 15, less than 10 were convicted. And what is the vagueness I was talking about when it comes to impeaching and convicting a federal judge? Well, the Constitution lays out that the judge has to not be in good behavior. Extremely vague. And I believe it's done that way on purpose to keep political shenanigans as far away from that as possible. But it is technically possible to have these judges impeached and convicted. Just don't count on it happening anytime soon for you. Anyway, guys, I hope you enjoyed this video. I hope you learned something today. If I got anything wrong, please let me know down in the comments. And I look forward to seeing you next time. Bye.